assignment 2 is due today, and I was like, wow, let me show you how you should have answered those questions in order for you to beg this decision. There are some who beg decision, who are with me, who are with me. So it's very clear that even though you are doing this module CPR, you cannot understand everything. That's why you need to consult people who knows. It's not a sin. Otherwise, you are alone. You cannot be alone. You need to have a people like us who understand these things, so that will tell you more and will give you more of evidence, because we have already done this thing. We know about this thing. So let's go to CPR question. Let's just take a question and then try to answer. There was some question which says choose the incorrect. In terms of the rules of criminal procedure, re-examination may be conducted by both the prosecutor and the defense. Precise cross-examination is confined to matter raised and covered during cross-examination. Succeed cross-examination is conducted by party which called the witness in the first place. So here we are choosing the incorrect, right? We are choosing the incorrect. So you must know that if we are talking about re-examination, there is no way that the re-examination can take place, can precede cross-examination. There's no way that re-examination can proceed cross-examination. Why? Because firstly, we have examination in chief. After that, we go for cross-examination. After we go for re-examination. So this is what happened in court. You called your witness. You go for examination in chief. You examine your witness. After examining your witness, we go for cross-examination. Cross-examination is me now who has to examine your witness, and you will examine my witness. That's how it goes. Then after that, if we still go on, we go for re-examination. So precede examination is incorrect. It doesn't come before cross-examination. Therefore, this one is incorrect. Let's go to another question. Another question that you should have got it now is the traditional. They said choose incorrect. Traditional plea bargaining is essentially informal in nature by the prosecution in accordance with the basic notions of fairness and justice. Does not entail the defense, is essentially formal in nature, does not entail a binding agreement. Let's be honest, guys. We have two types of a plea bargaining. We have a traditional and statutory. It is very clear that if we are talking about traditionally in law, mostly applied to common laws. Common laws are not something that is a formal in nature. It is informal. If we are talking about things that are informal, we have many things that we can talk about that are falling to common law, which are informal. Therefore, anything that is of a statute is a formal in nature. We have a statutory plea bargaining, which has already stated very clear that it is from the statute. So such a thing is formal. So all you have to do was to choose formal in nature, because that's incorrect. Traditional is all about negotiation, going to the state will come to you and say, hey man, we know that you have done the criminal, and if you can plead guilty, maybe you can get a light or harsher sentence. But it's up to you. It's up to the judicial officer or a judge or magistrate to impose a harsher or light sentence. So it's not up to the prosecutor. That's why the term formal, it's incorrect. You will have just get another marks for free. Another question which is very easier, which you should have got it. They said that choose the incorrect answer. When you answer the CPR, we must be a person who's intelligent and able to see what's going on. So there are two questions. We cannot care when you check the incorrect. You don't care about this one. You don't care about this one. You only check these two. They say a witness may, under no circumstances, be permitted to use or adopt a pseudonym for the purpose of the trial. This says that the witness may be permitted to use the pseudonym for the purpose of the trial. So it's very clear that a witness who doesn't want to reveal the identity will use the pseudonym or pseudonym for the purpose of the trial. That is very clear. So it's very clear that D is incorrect. You do not check those others. It means that if there are two things that they gave on the same statement, you check those two things only. Then you find the incorrect. Then you go to another question. It was very clear that you have to come here and check this one and this one, and then you find which one is incorrect. Then it is very clear that the witness may, under no circumstances, D is incorrect. You get the marks. Another easiest question, CPR. Choose the correct answer. Then there's A, there's a B, C, D. You are choosing the correct answer. They have given two things that you choose from. Number B says, in terms of section 153, subsection 1 of the CPA, a court is empowered to exclude the public from the proceedings. Then number E, in terms of this one, is saying that a court is under no circumstances empowered to exclude the public from the proceedings. You must know that the discretion is from the court. So it is very clear that the correct answer is number B. This was, in terms of this section, a court is empowered to exclude the public from the proceedings. It gives the court power to exclude the public from the proceeding. If you can open up this, you will see it's the same as in terms of Child Justice Act 63(5). It's the same thing. It excludes public from the proceedings of the children's court. That's all. You beg the free marks. Okay, let's do this question so that when we finish this question, maybe we can look at one of the question in the study guide, but I'm not sure. Yeah, we can or we cannot, or we look at some question. So let's just say this question says choose the correct answer. The expungement of a criminal records in South Africa laws is sanctioned by common law. Criminal records may be expunged automatically or on application by the person concerned. A pardon may not be reviewed by courts. You must know that the pardon can be reviewed by courts, and only president is required confess to pardon someone, but not all offenses can be pardoned. That's one you must know. The function of pardoning is the prerogative of the minister. No, for president, not for minister. Every person has the right to be pardoned in South Africa. I've already told you that some offenses are not likely to be pardoned. Then it goes by what type of offense. Then it is very clear. They said that expungement is sanctioned by common law. Expungement derives from the statute. So it means that derives from the statute. How is that be sanctioned by common law? So it's very clear that the correct answer is number B. Criminals' records can be expunged automatically or on an application by person concerned. Then you get the free marks. There was no. This was easy. This should have just answered those questions in less than 2 or 3 minutes. Another question which you have just begged free. So you should have got 25 over 25 here. There was nothing. Really. It says choose the correct answer. Appeal is concerned with the procedural accuracy of the proceeding. That is not appeal. Appeal does not check the procedure. The procedure is checked by review. We have done it in ILW, Introduction to Law, the difference between appeal and review. You must know. Review is concerned with the substantial accuracy of the proceeding. No. That is appeal. Appeal is the one that is concerned with the substantial accuracy. Then those things of the judgment is the appeal. Due to their difference emphasized, review and appeal may be lodged simultaneously in respect of the same merits. And then number E says the review is concerned with aspects such as incorrectness of the judgment. Let me tell you, the leave of appeal by the court, when there's a leave for appeal, it means that you appeal against the judgment, right? Not against how the procedure was being, how the court procedure was, right? So if you want to review, you review the irregularities of the procedure of the court. Maybe if remember, in the regional court, you need to have 2 assessors in the murder case. Then you find that there was not 2 assessors. Therefore, you can review such a case for irregularities. That's a review. But most of the case will have a leave of appeal. Therefore, you cannot appeal a case and review at the same time, because the case cannot have appeal and review at the same time. So it's very clear that due to their different emphasis, review and appeal may not be lodged simultaneously in respect of the same merit. Why? Because if there's a leave for appeal, it terminates the review. All right? So there's no way that you can appeal and review the same case simultaneously. So it means that the correct answer is C. This was just things that you must just use the mind without even opening a book. Okay, now let's deal with another question. So there was this question, they said that choose the incorrect, right? The accused must, without exception, only be sentenced by the judicial officer who convicted them in the first place. Come on, guys. In the court, the judicial can die. So if the judicial die, then what's going to be? So what if judicial is ill? And the judges are judges. There's cases that the judge can refer to another judge, say that, man, I won't be available, go and hear such a case. So there is no without exception that because I'm the one who had the case, I'm the one who must end the judgment. So it's very clear that number one is incorrect. But we are going to check other, maybe we may find another incorrect. So youth is generally regarded as a mitigating factor in sentencing proceedings. Yes, that is the truth. They are mitigating factors. It's a very clear sentence. An address by accused on sentence should not include facts. Yes, when you address, you don't need address to include facts. Maybe in America, there's some address where people said address the court. Then you address them, showing a remorse or sympathy, or not showing any remorse at all. Then we have number C. In criminal trials, previous conviction must only be proved after conviction. Yes, that is true. In a criminal trial, you must firstly be convicted. After being convicted, when it's about you're about to be sentenced, then they will have the prosecutor will check the previous conviction and then bring into the attention of the judicial officer. And then any judicial officer may pass sentence after consideration of the evidence if original judicial officer who convicted the accused is not available. That's truth. That's true. That's what I was telling you. That the judge can refer to another judge saying, "Go and hear the matter." The judge will go and hear the matter. I remember one day when I was in the magistrate, the judge could not make it, and then there was another judge who took over. So yeah, it's something that happened every day in the judicial. So number A is very clear that it's incorrect. That without any exception, there's not something like that. That because I'm the one who had the case, I'm the one who has to hand the judgment. Whereas number two is saying that after considering the evidence, any judicial officer can hand the judgment. So it's very clear that number A is incorrect. So you should have got a free marks here. So let me give you another question. How you should have answered. It's just a choose incorrect answer. Cross-examination can be conducted by both prosecutors and the defense. I told you that let me tell you, the cross-examination is when the party that called the witness allow another party to examine this witness. So it means that the prosecutor can examine the witness, and then the defense can also examine the the witness of the prosecutor. So this is how it goes. The prosecutor will examine the witness of the defense, and the witness of the defense will examine the witness of prosecutor. Remember, prosecutor must bring its own their own witness, and then the defense can bring. Let's go by the case of Senzo Meyiwa. You know, they want to subpoena Kelly Khumalo, who is the witness of the state. Therefore, they want to subpoena the person so that they can able to go to cross-examine her. Then the prosecution has made it clear in that case that they don't have intention of bringing Kelly, since although it's a state witness, they don't want to bring because it's unnecessary. However, the defense feels like it won't be a just trial. She must come and answer. then they were talking about something of a subpoena the person. Then that's how it can be conducted by both. If you have watched the proceedings, may only be conducted by the defense. It's very clear that it's incorrect. Not only defense can, the prosecutor can conduct cross examination. Therefore, we have already found the incorrect. Why we should read others? Because we have already found the incorrect. Even if we read others, it won't save us anything because the incorrect has already been found, and there cannot be many incorrect. Incorrect should be one. So it's very clear that it may only doesn't sound like it's correct. It's incorrect. Therefore, we found the incorrect one. Let's move to another one. Another question, another one that must be given an answer. So here it says that choose the correct answer from the statement. We do not even read what's going on. We have already have a two that shows that they are fighting against each other. Therefore, that the correct one will be found here. Number B is saying a conviction on the competent verdict must be regarded as an acquittal on the original charge. A competent verdict is possible even where it is not expressed. Then number D says that a conviction on the competent verdict must be regarded as a conviction also on the original charge. Those are the two. They are fighting each other, B and D. It means that if you find the correct one, if you find the correct answer here from those two, you find the correct answer, which is very clear that there's no way that if you convict someone on the competent verdict, it can be regarded as a conviction on the original charge. No ways. Because when you the conviction is on the competent verdict, it means that it must be an acquittal on the original charge. That's how it goes. And B, the correct answer. Very clear to find the answer. You do not know about the competent verdict. Well, we are going to talk about it when just watch my videos. You will understand more. Okay, another easier question, CPR. Then choose the incorrect answer from the following statement. Let's be honest, incorrect answer. Okay, in respect of statutory plea bargaining. Oh, okay. The agreements must be entered into after the commencement of the trial. The number E is saying the agreement must be entered into before the commencement of the trial. So there are two things that are there on the statement, and you must find the incorrect. Those others you don't read anything, because once you have a two that are against each other, you know that is the one you must prove the right one and the wrong one. Then that's how you answer the question in the CPR. Therefore, there are two that are against each other. Then let's see. Then number A is saying the agreement must be entered into after the commencement of the trial. So let's be honest. If you are going to court, do you think that if you have done something, you must plead after the commencement of the trial? I mean, we are on the trial, and the people will be like, "Oh, we forgot to plead. How are you pleading?" And be like, I'm not guilty now." After the trial, let's be honest, this is something that must be click on your mind, that even though I have never watched a legal proceeding, but this cannot be done after the commencement of a trial. So the correct answer, the incorrect one, is the number A. The agreement must be entered into after the commencement of a trial. There's no way that the trial started, then the person is coming to plead or whether he's guilty or not. No way. They have to plead, enter into the agreement before the commencement of a trial. So this one was very clear, and it was a very easier question. Another easiest question. Choose the incorrect answer from the following statement. The court must enter into a plea of not guilty. Okay. Oh, the plea of not guilty. Oh, the court can enter a plea of not guilty where on being required to plead, the accused refused to do so because the accused has not been furnished with further particulars. It's obvious. If you are not furnished with all particulars, they have to plead not guilty. If the accused pleads guilty by answering directly to the charge. Number B, it's incorrect. Why? You're answering directly to the charge. So if they said, "Did you kill?" and they said, "Yeah, I killed that person," you are answering directly to the charge. Therefore, you are pleading that you are guilty. And then Number D is saying that if the accused pleads not guilty to the charge, and this one say if the accused does not plead directly to the charge but makes an exculpatory statement in which he or she admits certain facts and denies others. They said, yeah, but I didn't actually kill. You see, there was this and that, then they plead not guilty. Then, but if you said, did you kill that woman? You'd be like, yes, I did it. Then they will plead guilty. Then it means that you are pleading directly to the charges. Therefore, number B is correct. Therefore, it's the one that you should have ticked. Let's answer the last question. I cannot do the 25 questions. If you wanted to get distinction, you will have approached me long time ago. But since you didn't approach me, it is very clear that you just wanted any marks that you got. So the last question that I'm going to provide to you, if you wanted to get to bank distinction, you will have approached me and I would have ensured that you bank distinction. But since you didn't came to me, so yeah, you will make it in the examination. If you can further watch my video, you can make it in the in the examination. So they said choose the incorrect answer from the following statement. The right to fair trial extend beyond the list of specific rights identified on section. Let's be honest, guys. Is there anything that can extend beyond the Constitution? I don't think so. So whenever you hear that this one is extending now beyond the Constitution, then it means that that thing is no longer part of the South African Constitution, because nothing can extend beyond the Constitution. Therefore, this one, number A, by virtue of just saying that it extends beyond those rights that are identified on Section 35 of the Constitution, it essentially make it itself incorrect. Therefore, this was an easiest question. We don't even go and read others. We just use our common sense, and then we know that if we know about something that is extending beyond a constitution, such a thing is no longer a part of South Africa, because South Africa, everything should be in line with the constitution. So thanks guys for watching the video. If you wanted to bank distinction, you know this is the only channel which provide the correct information and with the rightful information which you can use and pass. We'll be with you guys throughout the examination. We are available. If you have a question, you can just throw to our desk and say, I have a question on this CPR, please help me. Then we help you. Okay, we will meet on the next video. Good luck.